So what are dram shop laws? Back in the day, liquor was sold by a unit of measurement called a dram. Establishments that sold liquor were known as dram shops. And while we no longer use drams, the term stuck and is still used today to describe businesses that serve or sell alcohol.
The term dram shop law comes from the 18th century British way of measuring alcohol, which was called dram, and measured out to 3/4 of a teaspoon. Examples of drams include bars, pubs, taverns, and other establishments that served drams of alcohol. Today, dram shop regulations are applicable to all businesses that either sell or serve alcohol. These businesses include restaurants, bars, liquor stores, taverns, and stadium vendors. By 1779, Connecticut had passed 80 major laws concerning alcoholic beverages. The early United States continued to indulge and distill their own spirits. The early U.S. government attempted to impose taxes and controls on the alcohol enterprise, which was met in 1794 by the so-called Whiskey Rebellion in Pennsylvania. In 1933, Congress adopted the 21st Amendment, which repealed the 18th Amendment and brought an end to federal control of alcohol and prohibition. After that point, the individual states have been responsible for control of alcoholic beverages through dram shop liability laws. These laws stipulate that people who serve and sell alcoholic beverages may be liable for damages resulting from the consumption of those beverages. Liability in these cases may either be imposed under specific state laws, dram shop acts, or under general law of negligence.
There's likely no claim against the bar unless the person is underage or habitually addicted to alcohol. So if someone who's just a normal drinker and is over the age of 21 goes into the bar and has too much to drink, and as a result of that person having too much to drink, you get injured because maybe they run into you or they hit you or something like that, you probably don't have a claim against the bar in the state of Florida.
Arizona law requires the bar or restaurant to be responsible for the actions of the overserved or drunk patron. And this makes perfect common sense because the bar is taking actions to take away the judgment and coordination of a potential driver.
Pennsylvania law has codified dram shop liability, making it unlawful for any liquor licensee, including their employees or agents, to sell, furnish, or give liquor or malt and brewed beverages to, most commonly, any visibly intoxicated person or to any minor.
Today, businesses that sell alcohol must get training and adhere to liquor laws in their specific state. An example of a regulation that businesses must follow describes who they can serve alcohol to and when. Some violations include selling alcohol not covered under the permit, like hard liquor, when they only have a license for beer and wine, letting open containers off the premises, or selling or serving liquor to an underage person. Today, dram shop claims require 3 elements of proof. The establishment sold alcohol to the patron, the sale of the alcohol resulted in their intoxication, and the patron caused an accident or harmed third parties. Drunk driving accidents are an example of a case where a restaurant or bar could be held liable for intoxicated patrons who harmed third parties. Changes in the law have had a positive impact on exposure to liability in the relevant industry. To me, this means that over time it has become clearer when a restaurant or bar is liable for intoxicated patrons who harm third parties. At the beginning stages of these laws, it wasn't as clear to trace liability back to the establishment serving the alcohol instead of just the intoxicated person.